Peace, peace, peace. Come on, man. Alright. Peace, 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 peace. Welcome back to the UNI Versal Temple for the sun, planets, moon, and stars. I'll be your Lord of Hosts, Lord Messiah. And we're going back into how court cases move through the court. How cases move through the court system, rather I say. And we're going back into, we just did the criminal cases, so now we're going to go into the civil cases. Okay, so let's get it.
Criminal cases. Civil cases typically involve legal disagreements between individuals, businesses, corporations, or partnerships. A person can also be involved in a civil lawsuit with a government entity, such as a state, county, or city. Most civil cases involve disputes related to breach of contract, debt collection, monetary compensation for personal injuries, property damage, or family law issues such as divorce. The party suing in a civil case is the plaintiff, and the party being sued is the defendant. Steps in a civil lawsuit. 1. The plaintiff files a document, a complaint or a petition, with the clerk of the court stating the reasons why the plaintiff is suing the defendant and what action the plaintiff wants the court to take.
Right.
2. The plaintiff must state whether the case is eligible for arbitration according to court rule.
Right, so in other words, it says the plaintiff must state whether the case is eligible for arbitration according to court rule. So in other words, they have to state the statute or the rule that they're bringing this petition pursuant to. So pursuant to civil laws of civil rules of procedure 35.0, you know, we're bringing this case of the matter for blah blah blah. You know what I'm saying? So you give the statute whatever you're bringing the petition pursuant to.
Rule 3. A copy of the complaint and a summons are delivered to, served on, the defendant.
Right.
4. The defendant has a limited time, usually 20 days, to file a written answer admitting or denying the statements in the complaint. 5. The plaintiff and the defendant exchange information about the case. This is called discovery. 6.
Right.
The case is tried before a jury or a judge. Civil trial procedure is similar to criminal procedure, with each side having the opportunity for opening and closing statements, direct examination and cross-examination of witnesses, and introduction of other evidence. 7. The judge makes a decision or the jury gives its verdict, based on the testimony and other evidence presented during trial. 8. The losing party may appeal the decision to the next higher level of the court.
Right. So that's the basic steps in the civil lawsuit. You know what I'm saying? The plaintiff files the document or, you know, the petition. The plaintiff must state whether the case is eligible for arbitration according to the court rules. 3. The copy of the complaint or summons are delivered or served to the defendant. So the plaintiff, the one filing the complaint, must serve the other party, which is the defendant. The defendant has a time, you know what I'm saying, 20 days usually, to file an answer or respond to the petition that's served on him. Then the plaintiff and the defendant exchange information about the case. This is called discovery. So whatever the plaintiff is bringing forth toward the defendant has to, you know, bring evidence, I guess, in opposition to that or in his defense as a discovery, you know what I'm saying, to clarify, you know, what their statements are, what their positions are, and so forth. The case is tried before a jury or a judge. Civil trial procedure similar to criminal procedure. and the fact that they have, opening statements, closing statements, direct and cross-examination of witnesses, introduction of evidence. The judge makes a decision. The jury gives the jury gives their verdict based on the testimony and of evidence presented during the trial. The losing party may appeal decision to the higher level or of the court. So then they get into a court of appeals or case procedures. So, and that whole rundown, that's how that usually goes. Now, if you want to appeal, the plaintiff can appeal and the defendant can appeal. You know what I mean? So if the plaintiff feels like, well, yo, man, I feel like they should have honored my petition, and how did he not, or how did they not, do what I wanted them to do, then they can appeal for it. Or if the defendant feels like they shouldn't have been found guilty on that, then they can appeal that decision as well. So let's go.
Court of Appeals case processing. When an appeal is filed, the trial court sends the official case records to the Court of Appeals.
Right. So they transfer the information to the Court of Appeals, to the higher court. You know what I mean? To the next court that deal with that.
Appeal.
Because part of stuff, and don't they got the thing where they can't hear a trial twice? You know what I'm saying? So I guess that's why they have the appeal. You know what I mean?
Appeals. When the records and the attorney's written arguments, briefs, have been received by the court, the case is said to be at issue and is assigned to a 3-judge panel for consideration. All cases filed in the Court of Appeals must be accepted for review and decided by the court. The brief of the person filing the appeal, the appellant, contains legal and factual arguments as to why the decision of the trial court should be reversed. The person against whom the appeal is made, the appellee, has the right to respond to these arguments.
Right. So this is why, when we talk about the transcript, or when we're stating things for the record, when you're stating things for the record, that's more so for the transcript, which means after the case, if you choose to appeal, you're going to get a copy of the transcript to be like, listen, man, I stated this on the record. They ignored it. You know what I'm saying? I mentioned on the record that I served them. They ignored that. I mentioned that I filed the evidence. They ignored that. If they just denying you the due process of law, then you put all of this on the record and you state it. You know what I'm saying? And so forth and so forth. And that way, when you go back and get the transcript, you can put this as evidence. You know what I'm saying? To basically respond in your argument or support your argument of appeal or the reasons why you feel like they should reverse the decision.
Arguments. An appellate court does not conduct trials. It reviews papers, exhibits, and transcripts from the trial court. These items are the record on appeal and are used to determine whether the trial court correctly followed the law in making its decision. After they have reviewed the record, Court of Appeals judges may hear oral arguments from the attorneys before deciding the case and issuing an opinion. A majority vote, at least 2 out of 3 judges in agreement, decides the case. Court of Appeals judges have 3 choices when making a decision: affirm, agree with, the trial court's decision, reverse the decision, disagree, or remand the case, send the case back to the trial court for further action or a new trial.
Alright, part of self, let's run that back. So it says, after they have reviewed the records, Court of Appeals judges may hear an oral argument from the attorneys before deciding the case and issuing an opinion. The majority vote, at least 2 out of the 3 in agreement, decides the case. Court of Appeals have 3 choices to make. 3 choices when making a decision. 1, affirm or agree with the trial court's decision. In other words, they can say, well, I don't think, they can say, well, we don't think that the trial court, made any mistakes. Everything they did was right and exact. We don't really see, you didn't really present enough evidence to, really give a strong reason why we should reverse the decision. Or they could reverse the decision and disagree. Or they could remand the case send the case back to the trial court for further action or a new trial. Oh, pardon self, so I was wrong before. I guess they can hear the trial again, but I guess it has to go through the appellate court first, and then they'll send it back to that other trial, that other court. And ain't that some BS too? Maybe they do that because they don't want you to get awards in the higher court, so they send it back to that other court. Like, yeah, go back to them and deal with them, and most likely they'll give you the right decision this time. But you won't be able to sue them as if they did anything wrong. You know what I'm saying? So that's some BS. But yeah, you know what I mean? So anyway, let's go.
Supreme Court case processing. When a party wants the Supreme Court to hear a case, the party files a petition for review. The record then is transferred to the Supreme Court. After examining the petition for review and supporting materials, the court decides whether to grant or deny review. In almost all cases, the Supreme Court's review is discretionary. This means the court may decide not to accept the case.
Yeah, so alright, so then going back to where it says that the Court of Appeal, it says after they have reviewed the record, Court of Appeals may hear arguments on the so in other words, if they can like if they can say, well, we're going to hear the case, then it must have enough material support for the court to decide whether they want to grant the review. So in other words, most likely if they're going to grant the review, then it must be something good enough for them to even give it enough time. So if not, then usually if they're even going to look at it, then you must be presenting something to get their attention. And then I guess if you bring forth enough information to carry out with why you think that should go, then I guess they'll fully, they will, reverse the decision, you know what I'm saying, or disagree with the trial court, you know what I mean, or they'll remand the case, send the case back to the trial court for further action, or a new trial. Yeah, so like I said, it's like they hit the reset button, you know what I mean? But the reason why I think they hit that reset button, because like I say, if they admit that the trial court was wrong, then you might have reasons to sue them for doing things wrong and whatnot. So they just send it back to the court, so you can't get no lawsuit. But
Case. In that event, the last decision from a lower court is final.
Right.
When the Supreme Court decides to review a lower court decision, the justices study the record and the questions or points of law it raises. In most cases, the court will hear oral arguments from the attorneys involved in the appeal. During oral argument, the attorney for the appellant, the party making the appeal, highlights and clarifies the client's side of the case. Then the attorney for the appellee, the party responding to the appeal, presents the other side. The justices often question the attorneys about the issues and about the case law cited in support of their position. After reviewing the parties' briefs and hearing the parties' oral argument, the justices meet privately to deliberate and vote on how the case should be resolved. A majority vote, 5 out of 7 votes, decides the case, and the Chief Justice assigns a justice to write the court's majority opinion. Decisions of the court must be in writing. When issuing a written decision or opinion, the court may affirm, agree with, the judgment of the lower court, which means that judgment is final, reverse, disagree with, the decision of the lower court, meaning the Supreme Court's decision must be carried out, or remand the case, send it back to the trial court for further action and possible retrial.
Right. So there you have the process for civil cases. Alright, and we're going to end on that note, and I'll see y'all in the next video where we go into a little more extensive information and just learn some more about this whole court procedure. Alright y'all, see y'all in the next one. Peace.